Welcome to the Supreme Court Podcast.
All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
In the May 2013 elections, lawyer Raul Macalino ran but lost as vice mayor of San Fernando City, Pampanga. Less than 2 months later, the municipal government of Mexico, Pampanga, through its mayor, hired him as legal officer too, through a contract of service. His contract ran from June 1, 2013 to July 30, 2014, the monthly salary of 26,125 pesos. But even before he could finish his contract, the Commission on Audit came knocking, issuing a notice of disallowance to more than 5 months' worth of his salary and personal economic relief assistance, totaling 149,015 pesos. COA said Article 9B, Section 6 of the 1987 Constitution, and Section 94 of the Local Government Code both prohibit the appointment of a losing candidate to any government office or any government-owned or controlled corporation within 1 year from the election. Having lost his appeal to keep his salary before COA, Macalino now runs to the Supreme Court. Should the constitutional prohibition on appointments to government positions within 1 year of an election be applied to all losing candidates, regardless of their position or the jurisdiction of the office where they are appointed?
Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 7th of February 2025. Today we discuss the 1-year appointment ban on losing election candidates in the context of the case of Macalino versus Commission on Audit, GR number 253199, decided on November 14, 2023, penned by Associate Justice Jose Midas P. Marquez. And back here on the podcast is Attorney Luie Tito Guia, member of the Philippine Judicial Academy, Department of Constitutional Law, and former Commissioner of the Commission on Elections. Hi, Commissioner Guia. Welcome back to the Supreme Court Podcast.
Yeah, hi, Attorney Mike. I'm glad to be here.
So, Com Luie, let's discuss this concept of appointment ban for losing candidates after an election. Why is it necessary for there to be a ban? You lost the elections, so therefore for 1 year, you cannot serve in another capacity. What's the logic or rationale behind this rule?
Well, basically, it's because you lost in the election. According to the case of Macalino versus Commission on Audit, a candidate that who lost in the election has been rejected by the people. So appointing him immediately after he lost the election would be flouting the will of the people in a way, because despite the rejection or him not being the choice of the people, and he will be appointed, that is sort of going against the will of the voters.
Is there any specific reason why the period covered here is 1 year after the elections?
Well, it is in the Constitution, okay, Section 9B or Article 9B, Section 6 of the Constitution, and it's in the Local Government Code. So 1 year is a period determined by the people in adopting the Constitution and by the legislature in passing the Local Government Code to be sufficient to ban those who lost in the elections from being appointed to public office.
Mm-hmm. And one crucial issue here is who are covered by that appointment ban, because there was an argument here that at least according to this losing candidate, Macalino, he did not take an oath of office, and so therefore he tried to distinguish between contracts of service and job orders on the one hand from those who are serving in plantilla appointments. So he was saying, I did not take an oath of office, so therefore I'm not covered by this rule because his engagement was by way of a contract of service. But the court said, no, you're still covered. So what's the rationale for this, Commissioner
Well,
Guia?
the Supreme Court looked at the wordings of the Constitution itself and interpreted the wording according to the language itself. So it used the rule on verba leges in interpreting the Constitution. The Constitution is quite clear that the appointment is the ban on appointment of those who lost in an election is on for any office. So there was no distinction whether the person is a holder of a plantilla position or is a mere holder of the position by virtue of a contract of service or a job order. So the Constitution and the local government code did not distinguish, nor should the Supreme Court distinguish in coming up with this decision on that issue.
What about Macalino's contention that his appointment was in another jurisdiction, not in the same jurisdiction where he lost in the previous election?
Yes, he ran as a vice mayor or to be vice mayor of the city of San Fernando in the 2013 election. He lost, but a few weeks after, he was sort of designated to be the legal officer of Mexico, Pampanga, which is another municipality outside of San Fernando City on the basis of a contract service. And the Supreme Court said that it does not matter. Again, no. So regardless of where you may be appointed, that is covered by the prohibition under the Constitution and under the local government code, because the Constitution, local government code says any position, and any position would include those even outside of the constituency where one lost in the election.
Is there any explanation to this rule, Commissioner Guia? Because earlier we discussed that the reason for a one-year appointment ban is that the electorate rejected you, so therefore you cannot serve in any other capacity. But in this case, you may have been rejected by the city of San Fernando. Does that also count as a rejection by Mexico, Pampanga? For example, if it's in another position in government, not with respect to a particular municipality, say it's a national agency, is there any explanation for this?
That's actually a very good question, but at least in this case, the Supreme Court was relying on the fact that the language of the Constitution itself says that the ban on appointment of a candidate of a person who lost in a previous election applies to any office, and the interpretation of any office there is that it can be any office, whether national or outside of the constituency where the person lost its election. So it is an encompassing interpretation, and according to Supreme Court, that is the plain meaning of the provision.
But the question here, Commissioner Luie, is what happens now to Macalino? And in fact, this may also apply to all other losing candidates who served within 1 year from their election loss. Will they be required to return their salaries?
Of course, having served in office as a contract of service appointee, so to speak, he would have at that time received his salary commensurate to his position. However, the Supreme Court said that the decision of the Commission on Audit to disallow the payment of his salary is correct, and the notice of disallowance, of course, is accompanied by an order for him, as well as those responsible for hiring him and for releasing money or releasing his salary are to be solidarily liable in reimbursing the government of the amount paid for as his salary.
And for the general audience, when we talk about solidary liability, what do we mean by that, Commissioner Luie?
Well, when you say solidary liability, any of them can actually pay the amount in full, subject to reimbursement or probably compensation as between or among them. It means that the debtor or the creditor, which in this case is the government, can collect from any of them the full amount that has been paid as salary of or as fee of Attorney Macalino in this case.
Let me go back to Macalino, Commissioner Guia, because from his end, wouldn't this be unfair? Because he actually rendered service. Wouldn't he be entitled to at least not partial compensation for his efforts, for the work that he has done?
Well, according to the Supreme Court, there are some instances where, the principle of what is called quantum merit can be applied, meaning reimbursement can be tempered a little in recognition of the actual work performed by the person held liable. In this case, it was a clear violation of the Constitution and the law, and that the quantum merit principle does not apply when in this case, the contract itself is a clear violation of law. And the Supreme Court said that the contract of service is a clear violation of law.
And in fact, his being a lawyer was taken
Yes,
against him with the Supreme Court.
Yes.
He should have known that this is illegal under the law.
Yes, the Supreme Court made mention of that as well.
And to close our discussion, Commissioner Guia, what's our takeaway from this case? Perhaps a lesson for those who may lose in the upcoming elections that they could remember from this case?
Well, it's very clear, no? If you lost in an election, you cannot be appointed to any position anywhere, whether national or local or even far away from the constituency where you lost an election. And if you somehow get appointed through maybe in a plantilla position or as a contract of service hire or as a job order hire, and this applies not only to lawyers, no? Attorney Macalino is a lawyer, but to anyone who will lose an election, because when you get appointed and receive salary, you will be made to reimburse the entire amount that you receive, because your appointment is outright an illegality.
Mm-hmm. And this is also, and do we also take it to mean, Commissioner, that if you're running for elections and you sense that you could be losing from the elections and you intend to serve in another post, you should just instead withdraw from your candidacy just to avoid being subject of this 1-year appointment ban?
That's right. When you file your certificate of candidacy, when you are deciding to run for public office, you have to remember that when you lose, you'll not find any job in government for at least 1 year after the election.
All right. Very clear, loud and clear. Commissioner Guia, thank you once again for joining us to discuss this case. Former COMELEC Commissioner Luie Tito F. Here's Tiff Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
This week at the Supreme Court. Chief Justice Alexander G. Gesmundo, on Monday, February 3, 2025, led the celebration of the 89th founding anniversary of the Court of Appeals. Acknowledging the indispensable role of the appellate court in the judiciary, he urged the Court of Appeals to continue embracing technological innovations and reforms towards swift, fair, and transparent administration of justice. On the same day, the Chief Magistrate administered the oath of office to newly appointed Sandiganbayan Associate Justice Lord A. Villanueva, who previously served as Department of the Interior and Local Government, or DILG, Undersecretary for Operations, prior to his appointment to the Anti-Graft Court. Chief Justice Gesmundo and the Associate Justices also met with His Excellency Tul Traisorat, outgoing Ambassador of the Kingdom of Thailand, to the Republic of the Philippines during a farewell courtesy visit held at the Supreme Court en banc Session Hall. The Supreme Court en banc on Tuesday directed the House of Representatives, the Senate, and Executive Secretary Lucas Bersamin to comment on a petition challenging the constitutionality of Republic Act No. 12116, or the General Appropriations Act of Fiscal Year 2025. They were given 10 days to file the comment. On Tuesday afternoon, the Supreme Court started hearing oral arguments on the petitions regarding the transfer of the Philippine Health Insurance Corporation, or PhilHealth's excess funds to the National Treasury. The oral arguments will resume on February 25. The SC has clarified the prescriptive periods for value-added tax, or VAT, refund claims with the Commissioner of Internal Revenue, or CIR. The SC summarized the rules for filing administrative VAT refund claims under the relevant memorandum circulars of the Bureau of Internal Revenue and the Tax Reform for Acceleration and Inclusion, or TRAIN law. In a decision written by Associate Justice Alfredo Benjamin S. Caguiwa, the Supreme Court's Third Division held that for VAT refund claims filed before June 11, 2014, the 120-day period for the CIR to resolve the claim begins when the taxpayer determines that its submission of documents is complete. The case involved Dula Ship Management Philippines Corporation, which sought a refund or credit of unutilized input VAT for 2012. Dula filed its administrative claim with the CIR on March 31, 2014, and submitted additional supporting documents on July 28, 2014. In another case, the Supreme Court reiterated that extrajudicial demand is not required before an action for judicial foreclosure can be resorted to, unless required by law or agreed upon by the parties. In a decision penned by Associate Justice Mario V. Lopez, the court's Second Division granted the petition of Goldland Tower Condominium Corporation, which challenged the Court of Appeals' dismissal of its action for judicial foreclosure due to the absence of demand. Goldland filed a complaint against the former registered owner of a condominium unit and its subsequent owner. Goldland demanded for payment of the principal sum of 4,362,208 pesos and 14 centavos, representing the unpaid association dues, and in case of default, for foreclosure of the encumbrance over the condominium unit in accordance with Rule 68 of the Rules of Court. The court held that as soon as a debt becomes due, the creditor gains not only the right to demand, judicially or extrajudicially, its payment or fulfillment from the debtor. In addition, the creditor becomes entitled to the right to initiate foreclosure of the security as payment. Meanwhile, on Wednesday, February 5, the Supreme Court held the final leg of the information and recruitment drive for the Office of the Regional Court Manager for the National Capital Judicial Region in Quezon City. Senior Associate Justice Marvic M.V.F. Leonen delivered the keynote address, while Associate Justice Josep Lopez gave the welcome remarks. In the afternoon, a training on the electronic filing or e-filing component of the eCourt PH version 2.0 was also held, led by Associate Justice Rodil V. Zalameda and officials of the Office of the Court Administrator. The court took part in the Open Government Partnership or OGP Asia and the Pacific Regional Meeting held in Manila from February 5 to 7 in Taguig City. On Wednesday, the court led two side events on decongestion and the justice zones. On Thursday, Chief Justice Gesmundo participated in the roundtable discussion entitled Leadership in Action, Ambition and Collaboration for Strategy 2023 to 2028. Hosted by the Philippines, the conference brings together top government officials, civil society leaders, and policymakers from Asia and the Pacific, along with global and regional partners, to exchange experiences, best practices, and progress on open government initiatives and implementation on key issues. The event is organized by the Philippine government through the Department of Budget and Management and the Civil Society of the Philippines. Meanwhile, the Office of the 2025 Sharia Bar Examinations, or SSBE Chairperson, Associate Justice Antonio Tico Jr., has announced the court's approval of a financial grant for examinees from the Middle East. Sharia Special Bar Bulletin No. 3 outlines the guidelines for the grant equivalent to the actual reimbursement of airfare and accommodation expenses not exceeding 80,000 pesos. Qualified applicants must send the complete supporting documents to avail of the financial grant on or before March 15, 2025.
And that's your Supreme Court this week. I am Tiffany Dobletran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office, with Attorney Karen Martinez, Jay Rentilio, and May Sibal as researchers, Gary Enriquez, Lawrence Olanio, Brian Austria, and Victor Laranio as sound editors, and Tyke Flores and Jerome Batumalake as web editors.